Okay, now that we have understood question number 3a, now let us go to question number 4. So in question number 4, the first is, again see here, every question is related to case law question. KPS India Producer Company Limited having an average annual turnover exceeding 6 crores in each of the 3 consecutive financial year. The company has to appoint a company secretary. Advise the company by referring to provisions of Companies Act 1956, it is not 2013, as applicable to producer company relating to such appointment. This is one chapter every student is going to leave because they think producer company, they will not ask it is 1956 Act, etc. But they have asked this for 4 marks. Very, very dead easy question. How do you write this kind of an answer? So here it's very easy. You have to first write to KPS India Producer Company Limited, because they have asked you, what have they asked you here very clearly? Advise the company, because they have asked you to advise the company. Your answer also should be in the same format. To KPS India Producer Company Limited, dear sir, applicability of provisions of appointment of company secretary for a producer company. So when you write like this, the person who is correcting thinks that you already have a working knowledge of how things work. Next, section 581X of the Companies Act 1956 talks about this particular provision. Yes, you might not be able to remember section 581X, but you can definitely simply say that Companies Act 1956 provides for this producer company. And what is the provisions relating to company secretary appointment in producer company? First thing is, producer company, any producer company which is having annual turnover of more than 5 crores in 3 financial years, such producer company will be eligible for appointment of company secretary. Who should they appoint? Member of ICSI only, Institute of Company Secretaries of India, as what? Whole-time secretary, not part-time, whole-time secretary. And if they don't appoint, what happens? Under 581X, the penalty and the fine, 500 rupees per day. It is not overall. For each day of day, 500 rupees. For whom? The penalty is for two occasions. One is for the company. The second is for each of the officers. So it is not a small offence. It is a big offence under the Companies Act 1956 if you don't appoint a company secretary. However, there are some exceptions which you should quote in the exam if you want to get 3.5 or 4 out of 4. In that way, it is very easy to quote the exceptions. The company has made efforts. So company should prove some evidence that it has made efforts to try and appoint a company secretary, but it did not get the company secretary. But this doesn't happen usually in the real world. Next thing is, the company is having a weak financial position. If a company has weak financial position, it will get an exemption for not appointing the company secretary. So when you write this answer in this format, you can even write in form of a chart. It is very easy for the person who is correcting to understand what you're writing, and also it is easy for you to score marks. Yes, let us go to the next question. The next question is question 4b. Shaky Commodities Private Limited could not hold its 10th AGM meeting for the year 2016 by 30th September. The company sought extension of time for holding AGM from ROC, but failed to hold the meeting within the extended time too. So within extended time also they did not hold. Instead, it held the meeting 31st month, that is much later, and passed the resolutions thereat. Certain shareholders have challenged the validity of these resolutions. Referring to provisions of Companies Act, examine whether contention of the shareholders shall be tenable. So this is also a very, very nice question where they're testing your knowledge relating to AGM. Yes, so how do we write this answer? What all are the things we have to understand? What are the contentions of the shareholders? Can the shareholders' contentions be tenable? For that, section 96 has a very simple concept which everybody will know. Whoever has studied company law, even basics, they have to know this. First AGM of any company should be within 9 months of the close of the financial year, first financial year, or 6 months of the close of financial year for other companies, and the gap of maximum 15 months between two AGM. So this is a very simple provision which everybody will know. So what this provision says, that earliest of the above three conditions. So these three conditions are the earliest of that you must hold the AGM. So first let us write this in the answer. Then the extension. The extension is provided in proviso to section 96 subsection 1. So here in our case the resolutions are passed on 31st 3 2017 according to this particular question where they have quoted. They have done on 31st March 2017. So if they have done 31st March 2017, by going by these three conditions which we just studied just now earliest, we can write in exam very clearly it is invalid. So please try to connect the concept to the answer. Simply don't write what are these conditions and then finish the answer. They're trying to test your application of mind and how you are connecting the concept with the question and how you are answering. Then next you have to write section 99, penalty for not holding the AGM. The penalty is 1 lakh and 5,000 per day of default. So 5,000 per day, 10 days is 50,000. So 100 days if they've delayed, 5 lakhs. So it's a very, very big amount even for a big company or small company. Then the member shareholders can apply to the tribunal to call for AGM. So this is kind of connected to our question of shareholders. So here, is it tenable or not? Yes, definitely it is, because they have not held within the time limits prescribed under 96 or even in the extension provided in the proviso to 96 subsection 1. So this everybody knows, but how you present the answer makes a difference in how you are going to score the marks. The next question is very simple. From the following information with respect of two companies, compute the amount of companies have to be required to spend on amount of CSR. So this, just take these numbers and make the calculation. It's very simple. There's nothing great for me to explain over here, and it is easily scoring for 4 marks. This kind of question you can write in exam very, very easily. Yes, the next question. See, again case law. This whole paper is case law questions. So they're trying to test your application of mind. 4D. During the financial year 2016-17, Board of Directors of Care Automation Services Limited has issued shares to employees under Employee Stock Option Scheme. Ms. Excellent has recently joined the board of the company and asks you, the secretary of the company, as to what details are to be disclosed in the board's report for the year 31 March 2017 in this regard. Advisor. This question is totally memory question. They are just trying to test your memory and directly taken from the book. So how to write this answer? Now who is asking this question to you? Miss Excellent. Who are you? The secretary of the company, that is company secretary. So how can we answer this to get 4 marks? So the care automation case, to Miss Excellent, Director, Care Automation. So if you start writing like this, it looks really good and professional, as though you are working in the real world. There you tell, Madam, details to be disclosed in the board's report are, first thing, the options granted, then the options vested, then options exercised, then total shares, then the options lapsed, the exercise price, variation of terms, money realized out of this ESOP, total number of options in force, employee-wise details of the options granted. So this is your answer, disclosures in the board's report. But to get 4 out of 4, we have to first write section 2 subsection 37, which is nothing but the definition of employee stock option. Then we have to also quote section 62 subsection 1 clause B, which is enabling for our ESOP. Then rule 12 of the share capital and debenture rules, and in that rule 12 we have sub rule 9 for disclosures. When you quote all this, you get 4 out of 4. You may say, how I remember so many sections. It's okay, even if you can't remember that, at least these points is something which you can definitely remember and which you have to remember, and by this you will at least get 3 out of 4. If you remember other things like the definition section, the rule number 12, etc., 100% whoever is correcting has to give you 4 out of 4. Yes. Now let us move to the first question in this question paper, which is for 8 marks. That is question number 5A. So question number 5A, let us read it in detail. It's a little lengthy question. Radhika Textiles Limited has utilized the securities premium during the financial year 16-17 as follows: 15 lakhs against expenses for foreign travelling of directors, 5 lakhs for writing of the balance of preliminary expenses of the company, 10 lakhs distributed as dividend for the financial year ending 31 March 2017. You being the secretarial auditor of the company, you are not the company secretary of the company, you are secretarial auditor, that is, you are a practicing company secretary. Referring to provisions of Companies Act relating to security premium account, examine the validity. So they're trying to test whether you know the validity and whether you know section 52, that is relating to our securities premium account. So here for 8 marks, how you should write? First you should write what is section 52, what are the provisions in section 52. After you write that, you can directly go to utilization, that is section 52 subsection 2. In section 52 subsection 2, there first you have to give the conditions for utilization, and then let us try to understand whether this 3 points, 15 lakhs for foreign travel, 5 lakhs for writing off, 10 lakhs for dividend, etc. can be allowed or not. So let us first write the entire condition, because this is for 8 marks. So let us write the whole thing. First thing is bonus shares which are fully paid to members. We can have the utilization for what? Our securities premium account. Then writing off of preliminary expenses. So here writing off of preliminary expenses, see here they have given over here 5 lakhs writing off of balance of preliminary expenses of the company. So our Radhika Textiles Limited can use it. It is valid. So that point is valid. Writing off of commission paid, that is during the issue of shares, any commission which we have paid for the issue. Then premium payable on redemption of preference shares, even for that amount we can use from securities premium account. Purchase of its own shares under section 68, that is nothing but our buyback. Even there we can use securities premium account money. Then premium is not available for dividend. So that is very, very important, which we have to quote over there. And if you see over here, rupees 10 lakhs distributed as dividend for the financial year 31st March. So we can simply quote that since premium is not allowed, our company, that is Radhika Textiles Limited, cannot use that dividend amount. Then premium, you can also quote this: premium has having the same sanctity of share capital. So you cannot use it for whatever you want. So foreign travel is definitely not allowed. Even just reading the question, you'll think, how can we allow the directors to go on foreign trip? So even if you don't know company law, just by common sense you can write for this first point that no, it is not correct. And the second point is correct. They are valid. They can use it for preliminary expenses writing off. And the third point is again is not allowed. So when you write in detail like this, for 8 marks, you can definitely think of getting 6 marks out of 8 or 6.5 out of 8. And minimum you will definitely get 5 out of 8 if you write like this. Next is question number 5B. This question is actually for CS professional. I think by mistake they have asked over here. However, when they have asked an exam, we have to write it. So you can actually refer CS professional book for this particular question, and it is not there in our CS executive. Board of Directors of Daylight Limited decided to shift registered office of the company from Mumbai to NCR. Board has approved the change. Board has to seek the approval of the members of the company for going ahead with the legal formality. So they've given you some facts. For the EGM of the members to be held on 17th June. In this connection, you are required to draft notice of the EGM for shifting of the office and state and outside the state, and give explanatory statement in this regard. So drafting the notice and giving explanatory statement, it is in CS professional, but I don't know why they have asked here for 8 marks. So you can refer that book and write that same format which is there in the CS professional on that particular notice. So when you get such question, if you don't know anything, how do you try and approach it. So notice to each an explanatory statement. So you can simply write notice is hereby given on so and so date. So you can write date, time, etc. Then business to be transacted. Then you mention the business. Then resolution proposed, what resolution you are proposing to pass over there. And then after the resolution, any other business, special business if it is there, that one. And then you can go for the director. Who is the director who is giving the notice, that director's signature, etc., date, place, etc. And then explanatory statement. In explanatory statement, it is very easy. You have just have to give the different disclosures. So here, what are they asking you? This is directly related to shifting of the office. So there, even if you have not studied, generally from one state to another, what all you have to ask, like you can say the address, then the reason for the shifting, then how many shareholders are in favor of it. So such kind of reason, then justification for the shifting, then how will it affect the company's business. So all these kind of things you can write even if you have not studied, just by using your common sense. Now let us go to the last question, question number 6. In question number 6, again we have 4 parts. The first question is for 4 marks. The first part, Mr. Sunil Goyal, Director of XYZ Limited, wants to go on foreign trip. He wants to assign his office to the Vice President of the company. Mr. Sunil Goyal seeks your advice, again advice, whether he can do so. Referring to provisions of Companies Act, advise him on the matter. So when you want to advise him in the matter, you should know what concept are they trying to test you. They are trying to test whether you know the concept of alternate director. So how do you, when you want to get 4 out of 4, this is how you can nail it. To Sunil Goyal, Director, XYZ Limited. Same thing I have told in other parts of this video, you can watch that. Subject, advice on assigning office to Vice President, that is for the referring to Sunil Goyal. Then what are the provisions? First thing is section 161 subsection 2. What it provides for alternate director, that is absence of original director for 3 months, from India. Under old Companies Act it was from one state, but now they have made the amendment in new act, it is if they go out of India. So if it is for 3 months, if they go out, then they can they have to appoint an alternate director. So if the foreign trip is 3 months, so in this question they have not asked for, they have not told how many months, so they are testing that. So you can write if Sunil Goyal goes for 3 months for foreign trip, then alternate director can be appointed, that is the Vice President. He wants to appoint Vice President, that can be done. You should write that. So there, in that you can write the conditions. So the first condition is the Articles of Association should give authority for appointment of alternate director. Then the second condition, everybody knows, the person Sunil Goyal should have gone outside India for 3 months. Then not alternate director for the other directors. So the person who is being appointed should not be the alternate director for the other director. Then section 149 subsection 6, alternate director to be the independent director. So that one you have to mention. Then power. So the power means who can appoint. The question is who can appoint. The board of directors can appoint, or alternatively ordinary resolution at the general meeting should authorize the board to appoint. So original director has no power to appoint the alternate director. So original director has no power to appoint the alternate director, and we can have a resolution by circulation for this particular purpose also. Going further, what is the term? The term for this alternate director is not more than the term of the original director, or the first condition is death. So suppose it dies, the original director, Sunil dies, that, but you can't write that to, you're writing this to Sunil itself. You can't say, sir, if you die, then the alternate director position also will go. That you have to just mention. That is the death. Then vacation of office. So vacation office is when till the return of the original director to India. So till Sunil Goyal returns to India, he will the alternate director, that is in our case vice president, will hold office. If you write like this, you have to get 4 out of 4. There is no other option for the person who is correcting your paper. Yes. Going ahead, let us go to the next question, 6b. Question 6b. Mrs. Beautiful, aged 40 years, is the MD of Beauty Care Products Limited. She has received contribution to superannuation fund and leave encashment during her tenure with the company. During her tenure, that means it's over now. During the financial year 31 March 2017. Manager accounts of the company is not very confident if these perquisites are to be included in the computation of ceiling on remuneration specified in Companies Act. Referring to provisions of the Act, what should we do? Advise the manager. So how will you advise the manager? Here we go. So they are trying, answer 6b, they are trying to test Schedule 5 of the Companies Act. In that section 4 of Schedule 5, in that part 2, there what it says, perquisites are not included in the computation of the ceiling on remuneration. There is a list which is given in this Schedule 5 section 4 part 2. So there the first one is encashment of leave at the end of the tenure. Then contribution to the PF fund or the superannuation fund that is not taxable under Income Tax Act. So these things will definitely be perquisites which are not included in the computation of remuneration. It is okay even if they have given this and it will not be included. So here we have to advise the manager, right? So advise the manager, what will say? Manager need not include these perquisites in computation of ceiling, and for that reason we have the Schedule 5. So next everybody will ask, where is this answer? I did not find in the textbook, I did not find in the study material. That is why you should always study the Bare Act. At least study the schedules. Every exam they are asking at least one question on the schedules. There are only 7 schedules in Companies Act. So if you study that, definitely you can expect one question, and you will definitely score marks also in that particular question. Now, going further, we have question number C. Mr. Solid, a young professional of 29 years, has stayed in India for 150 days in the previous financial year. He does not hold any shares in Happy Retails Limited, which is a quoted listed company. Small shareholders have decided amongst themselves that he is proposed to be appointed as small shareholders directors who shall not be liable to retire by rotation, and his tenure shall be for 5 years from the date of joining the office of director. Examining the provisions of the Companies Act, state whether Mr. Solid can be appointed as the small shareholders directors. So here they are talking for 5 years. So here if you see the provisions for small shareholder director, the Act clearly says that it is only for 3 years. So how we will write the answer? No. 5 years is not possible in our Solid case. So Solid, Mr. Solid cannot be for 5 years. It is maximum for 3 years. So same way, if you elaborate that, you can easily score in this particular question. Last question. As a practicing company secretary, advise your client company regarding the matters relating to issue of shares with differential rights to be included in the board of directors report. So this is again direct memory question. So this exam they have asked very few memory questions, so that even the ones who by heart will not like this question paper, ones who like to apply the mind, it is very easy for them. How do you write this answer? Very simple. Matters to be included in the board's report. So you write first what is the governing law. Which law is it? Section 43 of Companies Act of 2013. Then Rule 4 of Companies Share Capital and Debenture Rules 2014. So in this Rule 4, Sub-Rule 4, what it says? The disclosures to be given in the board's report. What are the disclosures to be given in the board's report? In what occasion? It is relating to differential rights. Issue of shares with differential rights. What is the different disclosures which we are giving? So the first disclosure, again totally memory question directly from the textbook. If you memorize it, you can easily know, but the concept is total number of shares allotted, details of the differential rights, the price issued, promoters or KMP to whom it is issued, correct? Then the change in control post issue, after the issue, what is the change in control, the diluted earnings per shares as per the accounting standards, pre and post issue shareholding pattern. So in this question they're just again asking you to list. So in this particular concept, see, we have 1, 2, 3, 4, 5, 6 and 7. So we have 7 points and we are working for 4 marks. So when you write 7 points, they have to give you 3.5 or 4 out of 4. There is no other option. So I hope the discussion of this paper was very easy and you understood everything in this question paper. So we have discussed all the questions of our June 2017 paper. In the next video, the last video, I am going to summarize all the different concepts which they have asked in this June 2000 question paper of CS Executive Company Law.